44 and 45, State versus Henry Daniel Johnson. Docket call. Go ahead, Mr. Manning.
Judge, after extensive discussion with my client as well as reviewing the discovery, he maintains his innocence and requests a jury trial before a jury of his peers.
All right, and Mr. Hartwell, what any offers made to Mr. Johnson? I understand that he's rejecting all offers, but I want to know if any offers were made.
Yes, Your Honor. In this case, we're still waiting on the report from a phone dump. Because I hadn't yet had a chance to review that, no offer was made, as that could significantly impact what offer I would extend, depending on what is involved in that.
Okay. All right, court will place Mr. Johnson then on the court's jury selection docket beginning August 4th. And state and defense will be notified if Mr. Johnson ends up in the top 10. Is this a case that should be considered for special setting?
Yes, Judge.
State would request that, Your Honor, as there is a child victim and the potential for multiple experts that may need to be called for either side.
We're not going to set it today, but I will consider it.
Thank you, Your Honor.
Judge, ready on Mr. Hardy?
Court call State of Texas versus Mark Anthony Hardy, CR 25-77, CR 25-90. Mr. Hardy, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Do.
Thank you, sir. You can lower your name is Mark Anthony Hardy. Is that correct?
Yes, sir.
And Mr. Hardy, are you a United States citizen who reads, writes, and speaks English?
Yes, sir, I am.
In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Do you have any questions about anything that you have read and signed today?
No, sir.
Do you have questions about anything else before we proceed further?
No, sir.
All right, it appears that you have been charged by indictment in cause number CR 2590 with fraudulent use or possession of identifying information or identifying informational items between 5 and 10. Third degree felony does carry a range of punishment of not less than 2 years or more than 10 years in prison and a fine not to exceed $10,000. I see the plea agreement you've reached with the state is upon you pleading guilty. The state's recommending that the court assess your punishment at 8 years confinement in prison, with that prison sentence being suspended and you being placed on 5 years of community supervision. Also, as a condition of that community supervision, you would be placed on the intensive supervision program. There would be zero fine, but you would have court costs of $290 and reimbursement fees of $520. And it appears that the state is also asking the court to dismiss under section 1245, cause number 2025-195, which appears to be a misdemeanor burglary of a vehicle, and also cause number CR 25-77. Which is engaging in organized criminal activity. Mr. Hardy, is that your understanding of the plea agreement?
Yes, sir.
And that's what you're asking the court to approve?
Yes, sir.
Mr. Manning, do you believe Mr. Hardy to be competent today to enter into this agreement, that he's doing so intentionally, knowingly, and voluntarily?
I do believe he is competent and that he is entering into this plea intentionally, knowingly, and voluntarily.
Mr. Hardy, how do you plead to fraudulent use or possession of identifying information?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the evidence?
No objection as offered.
Evidence is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state is in compliance with all victim services. Restitution paperwork was sent out and none was returned to the state.
Thank you, Mr. Hartwell. Anything further from the defense?
Rest in closed, Judge.
All right, court will consider the evidence. All right, the court, having considered the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement. The court convicts Mark Anthony Hardy of fraudulent use or possession of identifying information between 5 and 10. The court, finding that this is a third-degree felony, assesses punishment at 8 years confinement in the Texas Department of Criminal Justice. The court suspends that sentence today and places the defendant on 5 years of community supervision. Court orders him to be placed on the intensive supervision program as a condition of probation. The court orders Mr. Hardy to pay $290 in court costs and $520 in reimbursement fees. Mr. Hardy, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. The court this day is also dismissing under section 1245, cause number 2025-195 and CR 25-77. Mr. Hardy, please step over with the bailiff to be fingerprinted. After that, you'll get more information from the probation officers.
Judge, I believe that concludes my business. I'll be excused.
We need to set Mr. Park's case. Cause number CR 22-192, State versus Joseph Leon Parks, motion to adjudicate or revoke. We have him confirmed in custody in the Hutchins unit. Do we know, is that Ms. Tabraham, is Mr. Parks down there on a prison sentence? Is that what he's in there for?
Yes, sir.
Okay. And I think I had it marked today for status of prosecution. Mr. Hartwell, do you have any information?
Yes, Your Honor. I know we've had some trouble getting bench warrants in the past. I believe the county he was being held in was not honoring those. Your Honor, state would request a bench warrant to get him wrapped up at this point. I think it'll be a one hearing issue, but we would like to get him wrapped up.
Was he the one that was he sentenced and sent to TDC before we get him bench warranted? Was he one of those?
I think he was, Your Honor.
All right, court will issue a bench warrant for Mr. Parks at the Hutchins unit. And we will set Mr. Hutchins then on the contested docket August 28th. All right, Mr. Manning, I think that does conclude you today. Yes, sir, you are dismissed. Thank you, sir. Appreciate your work.
All right, let's talk about that. This hearing had a little bit of everything: plea negotiations, jury trials, and a healthy dose of classic courtroom logistics. We start with State v. Henry Daniel Johnson, where the defendant, through his attorney, Mr. Cartwell, firmly maintained his innocence and requested a jury trial. That part went about as you'd expect: clean, respectful, by the book. The judge, Chris Martin, handled the exchange with his usual calm and clarity, confirming that no offer had yet been made due to an outstanding phone dump report, so no. Per trial resolution here, just a spot on the jury selection docket and a note that the case might need a special setting due to a child victim and the likelihood of multiple expert witnesses. It was brief, procedural, and left the door open for more complexity down the road. Then we shift to a very different mood with the case of Mark Anthony Hardy. Mr. Hardy entered a guilty plea to fraudulent use or possession of identifying information, a third-degree felony. Judge Martin walked him through the plea deal with his usual thoroughness, making sure Hardy understood every element: the suspended 8-year sentence, the 5 years of community supervision, 0 fine, and some very specific costs and fees: $290 in court costs and $520 in reimbursement. You could tell Judge Martin wasn't rushing anything. He gave Mr. Hardy room to speak up, confirmed his citizenship, asked about legal representation, and confirmed the plea was voluntary. Mr. Hardy kept things short and respectful, just a series of yes, sir answers, no attitude, no drama. His attorney, Mr. Manning, vouched for his client's competence, and the whole thing wrapped up pretty cleanly. No objections, no surprises. Judge Martin accepted the plea, followed through with the sentence, and dismissed 2 other pending charges as part of the deal, one for misdemeanor vehicle burglary, the other for organized criminal activity. Mr. Hardy was then sent off to the probation department to begin his supervision. And just when you think the docket's winding down, we get a quick administrative update on Joseph Leon Parks. This one wasn't about guilt or innocence. It was about logistics. Parks is in the Hutchins unit, and apparently getting him to court has been a challenge due to bench warrants not being honored. The state requested another bench warrant to bring him in, and Judge Martin agreed, setting the matter for August 28. It was short, procedural, but highlights how sometimes the biggest challenge in the legal system isn't the law, it's the paperwork. Overall, Judge Chris Martin kept a steady hand throughout the proceedings. Whether he was addressing a serious felony or navigating a stalled bench warrant, he remained patient, professional, and firm. Defendants were respectful, attorneys were prepared, and even though we had no fireworks, the courtroom moved forward with efficiency and clarity. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.